page. I also want to thank you all for coming out tonight because our best clients are educated clients because you make our job easier. So help us to help you. I've got a couple of my colleagues here who are going to be co-presenting with us, and we are just a small sample of our big team. Got nearly 40 attorneys who work throughout the state, and we're excited to present some information to you. There have been a number of legislative changes. This is my 22nd year. Jeff, I don't know what that is. It's not a jubilee. It's not a silver anniversary. It's something. I'll have to look up and see. Maybe it's like a paper anniversary, but I've never seen in my 22 years this many changes in the law. Mark, Nick, have you ever seen this many?
I've never seen, I've been doing this about 17 years and I've never seen this many or this many proposed bills. It just seemed like they never ended this year.
And Nick, I would assume you agree as well, yeah?
Correct. 9 years in, also the most changes I've ever seen.
So we've broken up tonight's presentation into bills that apply to both planned communities and condominiums. We've got a bill that applies to planned communities only, something for condo folk only. We're going to actually, in the interest of time tonight, we're probably going to skip over what the next legislative session holds because we have some kind of breaking news in terms of the CTA or Corporate Transparency Act for those in the know, and you will be in the know by tonight. And we also have two quick updates on some municipal laws that you may have some questions about, owners might be asking you about, so that way you'll be fully informed. So without further ado, there are 7 main bills tonight, then we're going to hit the CTA and our municipal bills. Mark, when do these bills go into effect?
We have no idea yet. It's 91 days. That's a very specific date. It's 91 days after the legislature adjourns, which we call it sine die. Hasn't happened yet. We probably expect it to happen in the next few months. So what we're talking about tonight that's been passed, signed by the governor, will likely go into effect sometime in September, but stay tuned. We just don't know quite yet.
And Nick, I think last year these bills went into effect last year. It was like the day before Halloween, right? Something like that.
I was thinking late October. I had it narrowed down that far.
Yeah. So, but don't worry, folks. We're going to keep an eye on all of that. So, I'm going to turn things over to you, Nick, so you can talk about Senate Bill 1432.
Thank you, Javier. And again, Nick Nogami, been at the firm for about 9 years. SB 1432, one of the better ones that's actually going to be put into place. And basically what this one says is that if your documents contain an unlawful restriction, and the easy example of an unlawful restriction is one that says, something that discriminates based on race, right? You all may not have seen something like this, or you may have. But it's kind of the easy one to say that, a set of CC&Rs that says, only Caucasians are allowed to live here, anybody else prohibited, obviously unlawful. In the past, associations have had other mechanisms to address unlawful restrictions. But what this bill is actually going to do is give us explicit ability to record an amendment to remove the unlawful restriction if it has been deemed as such by the board of directors. Now, one practice tip here, and again, I have to go a little bit quick, but one practice tip here is a lot of unlawful restrictions are not as readily apparent as a race-based one. So one thing that we are telling people to do is go through their documents with legal counsel and determine whether or not an unlawful restriction exists, whether it's race-based, whether it is familial status, something along those lines, and see what can be done and what you should be doing with legal counsel to record an appropriate amendment to address that unlawful restriction.
All right. Well, thank you, Nick. By the way, I should have mentioned, folks, if you have questions, if you have comments or complaints, feel free to put them in the chat. Mark is going to be monitoring tonight's chat while I run the PowerPoint in the background, and then Nick is going to be looking out for questions from the audience as well. So again, we're looking to share that information with you in an efficient way. Anything else to add, Nick, on Senate Bill 1432.
Sorry. Thank you, Javier. Yes, just to button up there, one part of the bill that I neglected to mention is that if a member of the association informs the board of directors that they believe that there is an unlawful restriction, the board will be obligated within 90 days of that notification to determine whether or not said unlawful restriction actually exists, based on the board's reasonable determination, likely working with legal counsel. And then within 90 days of that determination, if the board determines that a restriction is unlawful, they shall record an amendment to address the unlawful restriction. The bill also authorizes members to record an amendment to remove an unlawful restriction from their own chain of title. That's a fairly nuanced process that probably won't involve the association specifically. So the first part of this that pertains to association-specific conduct will be what you all will probably be focusing on.
And if you were wondering what the background of this bill was, it's the story that we heard from the state bar was that there was an Arizona Cardinal player who was looking to buy a property, somewhere in the, Biltmore area. It's an upscale part of Phoenix. And he saw one of these types of restrictions. He was offended. The NAACP caught wind of it. And rightly so. They went to the legislature and said, hey, this is something just as a matter of policy that we'd like to do something about. And it passed. So that's some information for you there as well. Another practice note. Tonight, you're going to notice that we have excerpts from all of these bills that have passed. We've got links at the bottom of these pages to the actual PDFs. So in your free time, if you have trouble sleeping and you'd like to just get a couple of extra links, feel free to click on these links. You'll be able to read the entire bill in its final native form. And so that's there for your viewing pleasure. And Nick, quick question. Does the law provide for a penalty if an association fails to record one of these amendments? I don't think it does it?
The bill does not. I mean, everyone here is probably familiar with the different remedies that owners may have against associations for failing to follow their documents of Arizona law, such as filing a complaint with the Department of Real Estate, or filing a superior court action. But the bill does not have a specific penalty in it right now.
Okay. Well, thanks, Nick. If you have questions or comments about our Senate Bill 1432, feel free to reach out. And while you're thinking of those, if you have any, I'm going to transition over to a collections issue. And remember, this is going to apply to both condominiums and planned communities. So unless you're a co-op, this all applies to you. So a lot of technical stuff here, but I'm going to explain it in the best way that I know how. And just by way of background, the majority of my background, at least my first 15 years, was exclusively in collections. So what does this bill say? Well, right off the bat, there is a statutory requirement that associations, before they foreclose, do what? They have to exercise reasonable efforts to communicate with the owner and offer a reasonable payment plan. Now, this isn't really ground shaking. It's something that, as a matter of public policy, just sort of makes sense. And frankly, we've seen association letters. I'd be hard pressed to see a letter out there where a board's not willing to work with an association member. So I don't think that this is a big deal, but nonetheless, that's there. But it gets a little bit more complicated as we go through. So what we've done for you is divided up on this table. On the left-hand side, it's what we would call pre-House Bill 2648, the one that we're talking about right now. And on the right-hand column, post House Bill 2648, what's going to happen once this bill goes into effect. So I think a lot of you, if you're board members, even if you're a newer board member, especially if you're an experienced board member, you know that the association has a statutory lien for assessments, late charges for assessments, reasonable collection fees, reasonable attorney's fees, and costs. And it's been like that since I've been practicing. But it's now changed. And a couple of things, and they're in red here. So late charges for assessments are still included, but they're only included if your declaration provides for them. So you're going to want to have somebody check that out. And the big change here applies to attorney's fees. So before, it didn't matter if those collection-related attorney's fees were awarded by a court or not. If your lawyers had just sent a demand letter, maybe done a payment agreement, maybe they're in the middle of a lawsuit, maybe they're 3/4 through a foreclosure. Didn't matter. Those attorney's fees were part of the lien. Now, this big change, and it's a pretty big change, those fees are only going to be part of the lien, secured by the statutory lien, if they're awarded by a court. So we just think that this is going to push a lot of associations into a kind of, let's call it a 2-minute offense, where the goal is to foreclose as quickly as possible, because that is essentially what the law is enticing you to do. Because otherwise, there's this risk that you could have spent money and it's not secured until the judge awards it. So keep that in mind. It's always good to move quickly with collections, especially now. The other issue out there is that the criteria to foreclose has been clarified. We've always sort of thought that this has been the case, but regardless, there's been this threshold. You have to be delinquent in assessments, payment of assessments for a period of a year, or in the amount of $1,200. And the law now just says that at the time the foreclosure is filed, you have to remain delinquent. So just some information there. Other things, application of payments. This is a pretty big one. And so you're going to want to talk to your managing agent. Here it's going to be Cadden. And, I'm sure as we get closer to implementation, the software vendors that they work with and their collection team are going to be working on this. You have to keep in mind, this bill is extremely new. And so I don't know anyone that's figured this out. We certainly are working on this on a daily basis to better understand it. So what are the changes? The law now says that the application of payments is modified. It goes now from unpaid assessments to due but not delinquent assessments, which is sort of an odd term. We think that the best way to think about this is if somebody's sending in a payment, it's maybe a quarterly assessment, and at the time you process the payment, the next quarterly assessment happens to be hanging out there on the ledger. You're going to probably want to apply that owner's payment to that upcoming assessment. That's going to be a little bit complicated. Don't forget, unpaid late fees are next, but they still have to be provided for by the declaration. So that's a change, and we've noted that in red on the right-hand side. Then we apply to unpaid reasonable collection fees. Those would be like the charges that you've contractually agreed to with, Cadden. Then we go to collection-related attorney's fees if awarded by a court, and finally everything else. So really, it's going to dovetail closely with where are you in the process of obtaining a judgment, because that's probably going to be the big shift there. And the final thing with regards to this bill is, as part of payoffs, you're going to want to keep track of judgment liens, and you also have to expressly retain ownership and control of the debts. There's some new terminology that it's introduced in the statute as well. I'm not going to get into that because it's a more technical thing, but we've covered sort of the basics, tonight. Again, copies of the statute here for your perusal. And there's just some things, that we've been, thinking of. Really, I think what you're going to be most concerned about is some of you may have resale assessments, capital improvement fees. And so you're going to want to talk to your attorneys to figure out, hey, we've got this in our documents. There have been these changes in the law. We'd like to know, are those still secured, through escrows by the statutory lien? Self-help charges, that's another big one. We think that there's a pretty good argument under the Condo Act, if you're a condo, to continue to have those secured by the statutory lien. If you're a planned community, probably want to talk to your attorneys. It's a little bit potentially trickier there. And also talk to your attorneys about pass-through charges that are authorized by either your planned community declaration or the Condo Act. So those are just things that are going to be continued to be examined. So it's a little bit more complicated. The sky's not falling, but it is going to require some more thought. And so talk to your attorneys, talk to your managing agent. Mark, Nick, anything that you think I failed to cover there, or any questions in the chat about these changes so far?
Well, there is a question in the chat. It says, how or what do you need to make changes to the collection policy?
Great question. So as a general rule, that would be considered a rule. And in the majority of associations, that's something that the board typically has unilateral authority, can do on its own. Do recommend you talk to your attorneys to make sure that you are everything that you have in that policy is consistent with your governing documents. So talk to Cadden, talk to us. We'd be happy to help. All right. If there are no other questions on the collection change, I'm going to turn things over to Mark so you can talk to us about meeting agendas.
Thanks, Javier. I don't see anything new on the chat, but if anyone has any questions or comments, please put it forward to the chat. So this is something that's going to absolutely affect everybody on the line, because we have a lot of board meetings. That's what you all do as volunteer board members, right? You like a good meeting. So what do we have to provide right now for board meetings? For executive session and open session, it's at least 48 hours notice of the meeting, right? That's basically it. And for executive session, we have to talk about what side of the statute you're going to be talking about, whether it's legal advice or whether you're going to talk about personal information of a homeowner, something like that. But as of right now, you don't actually have to give out an agenda 48 hours prior to the meeting or a week prior to the meeting. It just has to be made available at the meeting. So if you meet on Zoom, put it up on the share screen, just like you see our presentation. If you meet in person, have them sitting on the table, someone can grab the agenda. And the agenda is always subject to change. But now with the new statute that's going to be in place here soon with House Bill 2662, you have to actually make the agenda available really the same time that you're noticing the meeting. So right now, you don't have to, but in about 4 months from now, you're going to have to say, hey, here's when and where we're meeting, and here's an agenda. Obviously, it's subject to change, but you're going to have to make sure that agenda is made available, whether it's by posting or hand delivery or mail, really however you're already posting your meetings. A lot of you might use the website. Maybe Jeff's putting it on the Cadden's website, right? You're going to put that agenda in that same spot. You've seen the excerpt there. There's not a huge change. This is not earth-shattering in any way, but ultimately that's going to be the takeaway. The action item, when you notice the meeting, include the agenda too, and just remember as well, you can always amend that agenda, but don't play too many games with it, right? Don't say, hey, we're not talking about much, and at the last second say, hey, Jeff, put a special assessment on the agenda because nobody's here at the meeting, right? So no, let's not do that. Let's get in front of it, put on the agenda whatever you plan on talking about. All right, let's talk a little about resale assessments. So first off, we call these resale assessments, someone called transfer fees or due on sale provisions, but ultimately, what is a resale assessment? It's something generally that the buyer will pay when they buy a property within your community. The beauty of this is current owners usually don't have to pay a dime. It's the new people that are coming in. Now, let's be honest, how is it usually paid? The buyer and the seller will come up with who's going to pay it, whether that increases or decreases the purchase price. But ultimately, these are nice because it gets more money into the association's coffers, whether it's the operating reserve account, by new people coming into the association. We often see like maybe a percentage like 0.05% or a flat fee of $5,000 or something like that. Or sometimes, Javier, don't you see like a 3 months pay ahead of the assessment or 6 month assessment? And it's not actually a prepaid assessment, but it's a resale assessment, right? Based on what the assessment is.
All numbers and sizes, Mark.
All numbers and sizes. There you go. So right now, we don't have anything in the law that says who should have to pay these resale assessments. It's all based on the CC&Rs. This bill changes that. And it says, you know what? You can't actually levy this against somebody if it's a related party type of transaction and there's essentially no consideration. So let's say I am going to gift a property to my children or put it in a trust or gift it to my wife and put it in her name. I'm not charging anything to anybody. There, you can't charge that $5,000 resale assessment or 1% of the purchase price for that kind of related party transaction. But what if I'm greedy, right, Nick? And what if I say I'm going to charge my kids $100,000 for this property? Do they still have to pay the resale assessment now?
No, sorry. No, I don't believe so. No.
Yes, I
Oh
think
wait,
so.
sorry. Geez, sorry. No, no, no. I'm sorry. Sorry, I was fixing a typo.
That's
on
not
something.
nominal consideration. Maybe to
I
you
was
it is
listening.
big
I
money
was
bags.
listening.
For me, for
Sorry.
me, that's a lot of money. 100 grand's not nominal. So if I'm getting greedy and I'm charging my family members, then you got to pay it. Otherwise, you don't have to pay it. So what do you have to do? What's the takeaway? Well, in your CC&Rs, if you already have this resale assessment, it may already have one of these carve outs that says you don't get to charge it for certain related parties. But if it doesn't have that charge out, and then it comes down the pipe where this sale comes through and it's to my kid for free, you can't charge me. All right. And what if you don't have a resale assessment in your CC&Rs? You may want to consider adopting a resale assessment. It's one of our most popular CC&R amendments at CHDB law, probably right after short-term rental prohibitions. Just keep one thing in mind. For any CC&R amendment, including this, you may have a challenge by a homeowner based on the Callaway v. Calabria Ranch case. It's a Southern Arizona case that just basically says you have to have the amendment, quote unquote, tethered to your original CC&Rs. So there should be something about a resale assessment, transfer fee, etc., in your original CC&Rs, and then we can add a new resale assessment to get you guys some more money in your bank accounts. Back to you, Javier.
Okay, we're going to move on then to planned community only bills. And Nick's going to walk us through termination of declarant control. I guess a good question would be to ask, do we have any declarant controlled communities out there, right, Nick?
Yeah, in the room right now, you mean?
Yes. Yes.
I guess if there is a show of hands, feel free. Is anybody a member of a declarant control community right now or a developer control community right now? My windows aren't even set up very well. Generally speaking, what HB 2698 goes into is, if anybody's not familiar with it, declarant control, or sometimes known as developer control, is the period of time where a developer or some sort of real estate development company is in kind of control of the association, and they get certain rights and privileges in order to assist them in developing and marketing the association. Sometimes it's called declarant control. In the documents, you might see it at a period of time when there's a Class B membership, and that will be a membership that is specific to the developer. A lot of times the rights at issue have to do with different assessment obligations and different voting rights. And this is all in the period of time when the developer is trying to kind of build up the association and eventually market it and sell it off. Now, termination is when the developer or the declarant turns the association over to the members, and then all those rights that we were just talking about terminate, they go away. Historically, there are some legal authorities discussing when declarant control must be terminated. What this bill is going to do, what this law is going to do, is provide some specifics about when declarant control must end. And it also is going to provide specifics stating that if there's a set of CC&Rs, if there's a declaration that provides for declarant control that has a Class B membership provision in it, that the CC&Rs must also provide a specific term for when declarant control is going to end. That wasn't always the case before. And specifically, while there is a little bit of leeway there, declarant control must end no later than the day on which the second to last lot in the planned community is conveyed to a buyer. So that'll be the drop dead deadline for when declarant control must end pursuant to the statutes. This will also require associations after declarant control is over. And again, so when the developer is in control of the association as anybody who lives within such an association would know. The developer is the one that is providing for the maintenance of the association's common areas. The developer is selecting board members, that kind of thing. This statute will also specify that associations must, after the period of declarant control, continue to provide at least the same level of maintenance of the common area that the developer or the declarant was providing. This isn't to impede the declarant's ability to develop or construct or sell its lots, nor impede, or the association shall not impede its access to or use of the common areas in the same manner as other members. So one of the more pragmatic changes to the law, I would say, and one that's going to clear up a little bit of ambiguity that's always kind of been out there with regards to when declarant control needs to end.
Nick, I had a community that was under declarant control for 19 years.
Oh, well,
I have friends that had gotten married, divorced, and had children during that time. It's a long time.
19 years might actually be the record, if I'm being honest with you. So
I think it was. All right. Well, thank you, Nick. Any questions about declarant control? If so, reach out. And if not, we're going to move on to flags. And Mark, take it away.